Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. In this video, we are going to discuss a few case laws relating to res judicata. We are mainly discussing the negative case laws. Friends, you all know res judicata means res means subject matter, judicata means judicially decided. When once a matter is heard and finally decided, when the suit is directly and substantially based on the same material, when the parties are same or the legal representatives or the persons litigating under the same title, and the court may be the same or to another court, then in such a case, when a matter which is directly and substantially the same has been heard and finally decided, no court shall take up, no court shall try the suit. This is res judicata. Then what is res sub judice? Section 10 I told you, no court shall proceed for trial. No court shall proceed with the trial of any suit. This is the main difference. There, the procedure will not be followed, but it will be kept, that is stay. Here, they will not try, that means they will dismiss. Right. And in this connection, I want to reiterate that explanation 4, that is constructive res judicata. So that means whatever you want to take it as offense, whatever you want to take it as a defense, yes. So you have to file the same at the earliest moment. So if you file one defense at one time and later if you want to change it and go on for another defense, yes, the court will not agree. So the offense, the attack or the defense which you might and which you ought to have been made a ground, then it shall be, the former suit shall be due, okay. So if you file the grounds differently, they will not be accepted as per explanation 4. Right? Now coming to the negative examples of res judicata. So res judicata, you all know, when one thing is decided, there is no other point. But here, in the very famous case of Bar Council of India versus Union of India 2012, where an earlier writ petition was dismissed in limine. In limine means at the outset, that means without conducting any trial, where the earlier writ petition was dismissed in limine and not on merits. Definitely a subsequent writ petition raising almost identical points or identical grounds is not barred by res judicata. Why? Not heard and finally decided. Right? Explanation 8. Kabatti. So గుర్తుపెట్టుకోండి, res judicata will apply to the cases which are heard and finally decided. The second example, Union of India versus Association of Telecom Service Providers of India 2012. When the tribunal passes an order, without jurisdiction, no doubt an issue has come before the tribunal, but they are not sure whether they got the jurisdiction or not, but they have overlooked the point of jurisdiction. Authority lekunda, if they give some order, and definitely the basically first point is the order given by the tribunal without jurisdiction will become nullity. This me other in a class explain what is it. It becomes a nullity. So therefore, no res judicata. Andukani, the court should be competent to try the same. This is the word which you have to know. Competent court. Competency of the court. Of course, appellate court avasam panలేదు. ఆ కేసు ట్రై చేయడానికి అది కాంపిటెంట్ కోర్టా కాదా. నెక్స్ట్, this is Lourdhuswamy case, very important case. Williams versus Lourdhuswamy and another 2008 case law, where an earlier suit is concerned only with the possessory rights. So he filed a suit for possession and subsequent suit on title, possession, and subsequently he asked, the first is possession, of course it is decided. But once when once he files a case for title, title is different from possession. So therefore, it's not barred by res judicata. టైటిల్ ఇస్ డిఫరెంట్ ఫ్రమ్ పొజిషన్. మొదట్లో స్వాధీనం కావాలని అడిగాడు, స్వాధీనం అయిన తర్వాత టైటిల్ ఉందా లేదో ఫస్ట్లో లేదు, తర్వాత రికార్డ్స్ అన్ని తీసుకుని సబ్ రిజిస్టర్ ఆఫీస్కి వెళ్ళి రికార్డు తీసుకొచ్చాడు. ఎస్ ఈ ద ఓనర్ అన్నాడు. నో ఈ ఆస్క్స్ టు క్లెయిమ్ ద టైటిల్. కాబట్టి ఇది పొజిషన్కి టైటిల్కి చాలా తేడా ఉంటుంది. నో రెస్ జుడికేటా విల్ అప్లై. లాస్ట్ కేస్ రోషన్ మీను పటేల్. రోషన్ మీను పటేల్ వర్సెస్ యూనియన్ ఆఫ్ ఇండియా 2011. Here, Supreme Court clearly stated that the rule of res judicata is a rule of procedure. It's only a procedure aspect. Already decided, don't take up. But whereas rule of estoppel is based on the rule of evidence. 115, section 115 deals with, you all know, the promissory estoppel. But here, res judicata also, as I told you in the class, yesterday I told you that it is a verdict by estoppel. No problem. But the difference between estoppel and res judicata are estoppel is a rule of evidence, whereas res judicata is a rule of procedure. So please, these are the negative examples for the rule of section 12 of the CPC. So please have a cursory glance at the judgments, and definitely you will have the better idea regarding res judicata. Thank you.